Good afternoon, ladies and gentlemen, and thank you for joining our webinar today on Oh Canada. This is not the first time that our speaker has been here with us. Of course, our speaker today is David Altro of Altro Law in Canada. He has spoken with us, or to us, on several occasions in the past, and each time it is more and more entertaining and educating, and I'm sure today will be no exception. We've had tremendous requests for David Altro to speak, and so we're very excited for him to be here today, and I will not detract from any more of your time. So without further ado, ladies and gentlemen, I introduce you to David Altro. Take it away.
Okay, thank you so much, Christine, and thank you to the NABOR board for the opportunity to present today. And I have, of course, been before the NABOR board numerous times, actually in person also. And now we're in the land of COVID with the Zoom, so it's all good. It would be good if Cheyenne would put our PowerPoint presentation up, if everybody could see it. There it is. Incredible. Okay, so just a little intro for those that don't know our firm is I'm a Florida attorney since 1984. I'm a former partner at Holland & Knight. We have offices in Florida and in Ontario, at Montreal, in Toronto and in Montreal. Our clients are all over the state of Florida, but let's say that there is no place better than Naples and Collier County for sure. So could change the slide, please. Okay, so our lawyers are licensed on both sides of the border. And one of my partners, Samantha Wu, works very closely with me on the Florida real estate transactions and the probates and et cetera, et cetera. She was unable to join us today, but my bio and her bio is right there. Okay, next slide, please. So a little bit about our expertise and our services. We represent Canadians with U.S. real estate, whether they're buying or selling or financing. We do a lot of tax and estate planning for U.S. citizens living in Canada or Canadians moving to the U.S., immigration to the U.S., tax and estate planning for Canadians, Americans moving to Canada, and probate and settlement of estates in Florida. Okay. Next slide, please. So I'm going to talk about owning property the Canadian way. But before I do it, I was fortunate enough to chat with Christine just before, and she said there were questions, and I thought they were such great questions, and I thought I would just go into them right away, okay? And one of them is how title is held in Canada, i.e. in Ontario or Quebec or versus Florida. And I think it was a very astute question to ask, because the more you know about how things are done in Canada, the better you can speak Canadian to the Canadians. And like, for example, I'll give you a simple example. You know, if you say to the Canadian client, you're going to have doc stamps on the purchase, or let me say you're going to pay for doc stamps on the sale, or you're going to pay for doc stamps on the mortgage, they don't know, or title insurance, they don't really know what that is. So it's good to understand how things are done in Canada versus the States. But just to make it brief, okay, Ontario, where Toronto is a common law province, common law legal system, just like Florida. So we have in Ontario joint tenants with right of survivorship. We have tenancy by the entirety. We have life estates. We have all the same structuring as we do in Florida, but we have different probate rules. So there's different reasons to do different things. And trusts are very different, and limited partnerships are very different. So the thing is, in Florida, we don't like when clients buy in their names personally, because it affects tax and probate. I'm going to get into that now. Okay. I'm going to talk a little bit more further about some of these other questions that Christine raised, but let's move into how should Canadians own U.S. property? And when I say U.S. property, of course, we're talking about Florida. Change the slide, please. Okay, so what are the issues in a typical Toronto client buying a $1 million property in Naples? Okay, so for personal use, let's say. So I list them here, and the first one is the probate issue. So Florida probate is a big hassle for Canadian families if they pass away. And probate's very expensive in Florida and freezes the estate for extended amount of time. So Canadians get a lot of misinformation, and they get a lot of good information on the internet and bad information from friends. So we do not recommend typically that Canadians buy it in their names personally. Okay, so we prefer a trust. And the reason is it avoids the probate if they die. And there's no annual filings or accounting necessary. So it really simplifies rather than complicate, and no probate. And when we can tell the clients, look, there's probate in Florida, but we can avoid that by having own your property in a cross-border trust. And we can say, you're the trustee and the beneficiary, and there's no other parties, and there's nobody to pay. What we're doing, guys, is we're smoothing out the bumps and reducing their stress so that they can go forward with you as the realtors and close and not be stressed. Because what you see often is one spouse is worrying and the other spouse is not. They don't know what they're worrying about. So that's a big issue, and it's a great solution. Now, this trust is also effective to avoid other problems. For example, we have on a regular basis clients who one spouse becomes mentally incapacitated, and the other spouse calls up, or the lawyer calls up and says, clients want to sell, one spouse is incapacitated. What do you do? Well, the Ontario power of attorney doesn't work, right? So next thing you know, they're hiring the Outro law firm, and we're doing a Florida guardianship procedure in Collier County. Expensive, time-consuming. Doctors are appointed, social workers are appointed for psychosocial opinions. It's a nightmare. And meanwhile, you as the realtor can't close on the sale, right? So how do you avoid this? Again, the cross-border trust is super effective because the trust owns the property and the client owns the trust. If the client is incapacitated, there's no problem, no guardianship. It's simply the replacement trustee takes over, the other spouse or the adult kids. Okay. Now, the next issue here is about tax. Okay. Let's talk about some tax. Okay. So one of your questions that Christine advised me about before was tax crediting between Canada and the US. This is very important. So here's the situation. Canadian buys for $500,000 in Florida and sells for $1 million. Okay. So what happens is there's a capital gain tax to the IRS on the $500,000. Let's consider that net gain. You know, we know gross gain, net gain, there's a difference. So let's say it's net gain. The way it works is the tax that, this is really important so the clients are not nervous and stressed. The tax on the capital gain, if it's in the trust, is 20%. That's the lowest tax rate there is, okay? And you get that personally also, but the tax could be higher in corporate ownership, etc. So you get they pay the capital gain tax to the IRS. Sure, there might be FERPTA, and I'll talk about that after, but they pay the tax. What happens in Canada? Well, because the clients are Canadian residents, they also must declare the same capital gain to Canada. Okay, $500,000 gain, capital gain tax. Lo and behold, the tax in Canada, the rate is a little higher, 26.75 maximum rate. Florida, IRS 20, Florida State, 0. So what happens if the structure is set up properly, for example, in a cross-border trust, the tax paid to the IRS will be what's called a foreign tax credit under the treaty between Canada and the US as a deduction against the Canadian tax. So 26.75 to Canada, 20 was paid to the US, pay the difference to Canada. And that turns out to be exactly the same amount of tax that the Canadian would pay if they bought a cottage or a rental property or something else in Toronto. So what you're doing in your conversation with them, and of course you can refer them to us, we're going to give them tax advice, but they're not going to have double taxation if they buy and hold it the right way. Okay, I'm going to talk a little bit later about the wrong ways to hold. Okay, now this trust is also effective to protect the children of your clients after mom and dad pass away. We all have worries about our kids and leaving them inheritance. And what happens if you leave your kid the Florida property worth $1 million, and after the kid inherits, has a marital problem and a divorce, and the ex is trying to get at it, right? So what happens is if you don't have the right structure, the ex is going to get at it and call it a marital asset. In the trust, though, if your client's kids inherit after your clients pass, they have protection in the trust. It cannot be part of a marital asset if they have a divorce. Also, it protects the kids in the event that the kid, after inheriting inside the trust, has a bankruptcy, has financial problems. These ring very well with clients. Okay, let's change the slide. Okay, now this is another great tax question, and there's a copy of a front of my book, Owning U.S. Property the Canadian Way, 3rd edition. This is the leading book on Canadians owning U.S. real estate. So this is the financing question, okay? In the States, we all know, and I'm a U.S. lawyer, if you have a house and you have a mortgage, the interest is tax deductible. Beautiful. That's not the rule for Canadians in Canada. You buy a house in Toronto, you pay $1 million, you get a mortgage for 600 grand, you're not deducting the interest. How can a Canadian owning U.S. property deduct the interest? Okay, there's 3 scenarios. Listen carefully. The first scenario is Canadian is buying a property in Naples for $1 million, needs a mortgage of $600,000, goes to the bank, RBC, for example, gets the mortgage, and is the interest deductible in Canada? Answer, no. Why not? Because it was purchased, it was borrowed for the purpose of buying a personal use property. Scenario number 2, client already owns the property, has a $600,000 mortgage with Bank of America or Wells, and wants to refinance it with RBC, Canadian Bank. Then is the interest deductible? Answer, no. No change. Third scenario, the client has a $1 million property in Naples, has no mortgage. Now is thinking, well, you know, with the Canadian currency exchange and the very, very low interest rates, and maybe I should do some leverage. I'm going to borrow $600,000 from the bank and bring it back to Canada and invest it in my portfolio. Now the interest is tax deductible under Section 20, bracket 1, bracket C of the Canadian Tax Act. And that's how you do it. Next slide. U.S. estate tax. Okay. Now, U.S. estate tax is a moving target. And it's really important to understand it. And the rules are not the same for Americans as Canadians. Okay. Right now, under President Trump's 2017 Tax Act, known as Tax Cuts and Jobs Act, the exemption is $11,700,000. What does it mean? It means for a Canadian, you have $1 million property in the US, but husband and wife's worldwide estates under $11,700,000. Under the treaty, no tax on death. It's a good amount. Here's what's going to happen. In that Tax Act, sorry, it's got a thing came up on my screen. Under the Tax Act, that exemption drops to $5.5 million on January 1st, 2026. Well, there's a lot of Canadians buying in Naples that have a stake over that. The next story to understand is new President Biden will be reducing the exemption probably for January 1st, 2022 under his new tax plan. And we anticipate it will bring the exemption down to 3.5 to 5 or 5.5 million. So a Canadian who's got $1 million property in the US and has a worldwide estate over 5 or 5.5 million will have a US tax on death unless there's planning. Okay, so let's take a look at some planning for the high net worth clients. Turn the next slide, please. This is a diagram of a different kind of a trust. We call it a cross-border irrevocable trust. Okay, it's got tax provisions for both sides of the border. It avoids double taxation, and it avoids probate, and it avoids incapacity issues. It does provide creditor protection, and it also protects against the US estate tax for Canadians. Okay, whether the exemption under President Biden's new act is 5 million or 10 million or 1 million, doesn't matter. So it's very effective. So this is another way of owning. So if you're representing people who are in the process of buying, and let them speak to us, we can structure them the right way, and this will reduce their stress, and they won't have to worry about situations where they call their accountant in Canada who doesn't understand the rules and says them, don't buy, okay? Or they speak to their lawyer who says, I guess the rules are the same in the States as Canada, and they're not. You know, lots of misinformation out there, and our job's to demystify, and then we're kind of a one-stop shop, and we'll do all the documents. Next slide, please. Okay, here's 5 tax traps for Canadians who own US property. Okay, and I would say that this goes back to the question about the different tax rules. This is very interesting. Okay, turn the slide, please, and we'll go into it. Okay, so a Canadian, okay, should a Canadian own in a US limited liability company? Now, LLCs are super popular in Florida, and I use them a lot for Florida-based clients. I do. They're good. They give you creditor protection, and they're disregarded for tax, so it's the low personal tax rates. It's a win, but it's a loser for Canadians. And if you catch anything out of this seminar, it's do not recommend your clients buy in an LLC. And if your client is dealing with you and a different competitive realtor, and they say, you know, we were suggested to buy it in an LLC, and you can say to them, that's going to result in double taxation for Canadians. Speak to David Altro. You have now done a great job, and you're going to have that client. Okay, so LLCs we do not have LLCs in Canada, limited liability companies. Therefore, there's a double taxation problem, and that's the worst situation. So stay away from that. Next, revocable trust and Florida land trusts. Those are not good for Canadians. They're great. They're fine for American or US Florida residents. But again, we don't have revocable trusts, and we don't have Florida land trusts. So it turns into a double taxation for Canadians, which is the tax is paid by the individuals on the US side, by the IRS, but Canada taxes the trust itself and no credit, and then double taxation. Next slide, please. Okay, limited partnerships. We do use limited partnerships a lot. I'm going to talk about them when there's rental properties. I come into that. But Canada does not have limited liability partnerships, LLPs. Canada does not have LLLPs, limited liability, limited partnerships. So if you go to a lawyer who says put it into a LLP or an LLLP, you're going to have double taxation. Those are bad things. A LP is fine because a Florida LP, we do lots of them, is treated tax-wise the same way in both for the IRS and CRA, Canada Revenue Agency, and no double taxation. So again, got to be very careful. Next slide, please. Gifting. Gifting is a really interesting area and a tax trap. Give you an example. I have clients, they live in Toronto or London or Hamilton, Ontario, and they come down and buy a house through you. They pay 400 grand. And then they go to the community pool, and they meet the neighbors, and the neighbors say, so how did you buy the property? And you say, husband and wife. And they say, you have kids? Yeah. You better add on the kids. Okay. Why? Well, these people who are giving you this advice, we call them poolside lawyers, right? They give a lot of advice, okay? And they don't know why they're giving the advice, but they say to avoid problems. So you run over to the title company and you add on the 2 kids. Okay, what's happened? You have a $400,000 property. You now have 4 owners. Therefore, 2 kids, each kid has a $100,000 value. Okay, so did the kids pay for that? Okay, I got 3 kids. I haven't noticed them paying for hardly anything. So I'm pretty sure the kids did not pay, right? So if the kids didn't pay, it's a gift. Now, gifting rules are different for residents and non-residents. For non-resident aliens, such as Canadians, that triggers, get this, an immediate US gift tax at 40% payable immediately by the donors, mom and dad. Okay, that's not the rule for Americans. That's the rule for non-residents. So watch out. Don't do that. To avoid problems with the kids, put it in a trust. Let the parents control it. Who wants to have the kids be on title, and then the next thing you know, Junior's having a divorce and there's a big lawsuit, or Junior's got financial problems and gone bankrupt. Next slide, please. Joint tenants with right of survivorship. Okay, what's that? That's typically husband and wife. In Florida, we call it tenancy by the entirety, but it's joint tenancy with right of survivorship. Husband and wife, first one to die, no probate. Hey, sounds pretty good. It's not that good for Canadians. Why? Number one is, of course, there's still probate on second to die. So that wasn't so good. The other problem is probate is simply in the Collier County at the court. The real problem for the Canadians is US estate tax. So joint tenancy with right of survivorship or tenancy by the entirety doesn't protect first spouse from US estate tax. That protection is for Americans. Husband and wife are both Americans, first spouse dies, there's no tax. Husband and wife are Canadians with a US property, there's tax on first spouse to die if they're over the exemption. So, not really a good way to go. Next slide, please. Okay, let's talk about another way Canadians own. And you're going to hear this. Put it in a corporation. Put it in a corporation. Okay, it's not the end of the world. It's not so bad. But there are some problems on the Canadian side. Okay, for example, Canadian tax rates for where you have a Canadian, let's say husband and wife, someone tells them, set up a Canadian company, you'll be the shareholders and you can use it personally. Hey, great, $1 million property in Naples, rental value of, I don't know, 50,000, let's say, and it's probably more. But the parents, the husband and wife are not renting it out, they're using it personally. So, what happens is the Canadian tax revenue agency says that use of it is a Canadian taxable benefit. And if there's a $50,000 rental, hypothetical rental value, you have to add $50,000 to your income and pay tax on it to Canada. That is a bad plan. So Canadian corps is not a good way of owning if you can avoid it. Next slide, please. Okay, now let's turn to rental properties. Now, this is not personal use properties, so now corporate ownership is much better, okay? And what we do is we set up a Florida corp and we have it owned by a Canadian corp and you're on top. The clients are on top. And that avoids US estate tax, avoids probate, and gives you creditor protection. It's pretty good, but let me tell you that it's not good tax-wise. Why not? Because President Trump is going to raise the corporate tax rate to 28%. Okay, that's a very high rate. Right now it's 21% under the Trump tax. So it's going up to 28, and that's higher than the Canadian tax also. So we're not recommending the use of corps right now. Next slide, please. So what are we recommending for rentals? If you're fortunate to have a client that's buying 5 or 10, who's got a portfolio of more rental properties or an apartment building or a strip shopping center or whatever, this is a good structure. We create a Florida LP, not LLP, not LLLP, but an LP. And we have a Canadian corporation as the general partner, owning 0.5%, and the clients own 99.5%. This gives you creditor protection, avoids probate, very effective for rentals. Next slide, please. And remember, for rental properties, it's very important, if you want your clients to buy and not be stressed, that they get protection against liability. I mean, they have, a lot of people are doing short-term rentals now, very lucrative. So it means there's a lot of tenants coming and going, and they're having parties, and they're having what's called invitees. And if somebody has a slip and fall and a head injury and dies, there's going to be a big lawsuit. So creditor protection or liability protection means the sole recourse of the judgment creditor is the property, but not come to Canada and take away all the assets. This is for a high net worth clients with high net worth properties, rental properties. We do a Florida LP, and we don't have it owned personally. Instead, we create an Ontario limited partnership to own the Florida limited partnership, and clients are on top of that up in Canada. Avoids US estate tax. Very important, because those are high net worth clients and they would have US estate tax. So we clear up all of their issues. No creditor, creditor protection, no probate, no incapacity, no US estate tax, protection for the kids. And this is a more complicated structure, more involved, but this is what is needed for the high net worth clients with the high net worth properties. And we use it also for personal use also for high net worth clients. Okay, and we can use it if clients already own a property in their names personally. We always have structures where, let's say, for example, they already own the property and they have it in their names personally. And lo and behold, you've been to this seminar today and you speak to them and you say, you know what, your $1 million property or $2 million property should not be in your name personally. You better speak to David Altro. We do have structures to transfer over into the, without triggering tax into these structures to get those protections today, even if they already own it. And that's important, without tax. Yes, next slide, please. So capital gains tax, there was a question about capital gain tax, and I wasn't sure exactly what the tax, the question was, but there's a lot of aggravation about the 15% withholding. It used to be 10%, but it's gone up to 15%. So where you have clients who are selling and they're not having much of a capital gain, it's ridiculous to send 15% of the gross sales price to the IRS. So what we do is we tell the title company, keep it in your escrow and we'll file for a withholding certificate from the IRS. You know, I'll give you an example. $1 million property, they bought it for $900,000. They renovated for $100,000. Now they're selling for $1 million. There's no gain. There's no net gain, but the IRS wants $150,000. So we don't send it and we have the title company hold it and we file to get it back, to get release of it, okay? So that's FERPTA. Now, I want to talk about something special, 1031 like-kind exchanges, okay? I don't want to burst your balloon on these because I know you love these, but it doesn't work for Canadians. So if you're recommending to the Canadian who owns that property with a big gain, and you're saying, no worries, you don't have to pay the tax, buy another one, do a 1031 like-kind exchange and defer the tax. Wonderful for American residents. Doesn't work for Canadians. Okay? If they set it up and they defer it, here's what's going to happen. The capital gain that they already have, I'll give my example. They paid $500, it's worth $1 million. They have a $500,000 gain, which is $100,000 of tax to the IRS. If they defer payment of that tax now under the 1031, on the Canadian side, they can't defer it. They have to pay it. There's no deferment. There's no 1031 like-kind exchange in Canada. So they're going to have to pay that tax to Canada, not pay it to the US, but pay it to the US downstream when they sell. At that point, they'll have paid the tax to Canada. Now they'll pay the tax to the US 5 or 10 years later, and they've paid double taxation. Not a good strategy. So the better strategy is pay the tax to the IRS, declare it to Canada, get a credit in Canada for the tax you paid in the US, and just pay a small difference to Canada. That's the way to go. Next slide, please. We can pass this one. So here's some questions that come up. Is your Ontario will and power of attorney valid in Florida? This is a question that I would bet many of you have had this question. The answer is no. That's the answer. So they need, the Ontario will does not protect you in Florida from probate, and it's not even valid in Florida. So the thing is, I mean, it could be considered valid, but it doesn't respect the formalities of wills in Florida. So generally, it's a huge hassle. But even if it's valid, it's subject to Florida probate. We rather our clients enjoy their properties, but if they pass away, the estate is exempt from Florida probate, and you achieve that by the cross-border trust. Okay, powers of attorney, same problem. They're not valid. The Ontario powers of attorney don't work in Florida. Okay, so if a person is incapacitated in Florida, owning a Florida property but resides in Canada, can't use an Ontario power of attorney to sell the property. And that's a huge hassle. So the guardianship has to be done. We do those kind of things. But the better plan is don't own the property in your name personally. Okay, I think we can pass that topic. Next slide, please. Americans living in Canada, well, you guys are not too concerned about that. We'll let that pass. Next slide, please. Okay, so now I want to just come back to about other questions that Christine, I thought they were great questions. How has COVID affected Canadians buying and selling in Florida or travel, right? Well, let's talk about travel first, okay? We're in a lockdown in Canada, okay? I'm in Toronto. I can't come to Florida right now. I can't even go to Montreal and visit my son and grandkids, okay? So we're not allowed to move around. The border between Canada and the US is basically locked down. So how can Canadians go to Florida? They can fly to Florida, no problem. Now, when they come back, if they fly back to Canada, there's some crazy restrictions, which is you have to go to a hotel for 3 days, monitor designated hotels that the government watches, and then you have to quarantine for the balance of 14 days at home. That is not something Canadians want to do. So how do they get around it? If you drive, you can't drive to Florida. You can't get across the border from Canada to US in a car because the border's locked down. How do you do it? You fly from, let's say, Toronto over to Buffalo, pick up a rental there and drive down if you so wish. Okay? No, that's not how they do it. They, and then they drive back you can fly back and not have a problem that way. Now, there is a big incentive right now for Canadians to fly down to Florida to get the vaccine. So this is going on a lot too, okay? Because the US has done an awesome job in getting the vaccines, whereas Canada is begging for them from, the Pfizer and et cetera. So a lot of Canadians are going down for that. Now, how are Canadians buying or selling? Canadians are still buying like crazy, okay? Why? Because number one, the market is hot in Florida, in Naples area. So as soon as the market starts to get really hot and it's going up, one person tells another person, articles are written. I've been quoted in Globe and Mail and asked about this, et cetera, which is the major, that's like the Wall Street Journal for Canada, Globe and Mail. So Canadians are buying a lot. You guys know better than me how hot the market is. Also, the Canadian dollar strengthened by about 10 cents over the last while, so that's great. And thirdly, Canadians we're all in a lockdown and we're frustrated, and we know as soon as it's over, we're gonna party hard, okay? And we wanna be in Florida, and we didn't like having to stay in Canada in the snow this winter. So there's lots of desire, okay? On the other hand, there's a lot of Canadians who didn't go to Florida. I think 44% of snowbirds didn't go or something like that. I don't know if I'm right on that stat, but I heard it. So there's a lot of Canadians who decide to sell for two reasons. One is don't know when they're going to be able to go. Two, the prices have gone up a lot. So there's a lot of action. So Florida will always be number one attraction for Canadians. And Canadians are the number two highest quantity of investors in Florida and in the US, next to our friends in China, from China. So I think I've gone through my questions that you asked and given you an overview. If you have any questions that you can do now, I don't know if Cheyenne has set that up. I'm glad to respond. I believe this is being recorded. That's fine. And if you'd like my PowerPoint presentation, my pleasure. Cheyenne, I turn it back to you. I don't know if there's Q&A or not.
Yes, we do have a Q&A and we've got a few questions piling up. So the first one is, would you mind repeating when tax is deductible in Canada? For example, putting money into a portfolio. Very
good question. The only time a mortgage interest to a U.S. for the bank in Florida that gives you the mortgage, the only time the interest can be deducted for a Canadian, for Canadian tax purposes, is if the money was borrowed not to buy the property, not to refinance the property, but to simply get a mortgage where they did not have a mortgage on the property, already own it. They already owned the property, had no mortgage. Now they put on a mortgage. They take the money back to Canada and invest it with their financial advisor, or they invest it with their financial advisor in Florida. Then the interest is deductible.
Okay, next question. Hello, all this information is also valid for any Canadian resident, not only Canadian citizens, right?
Excellent question. Canada taxes on residency. That means if you live in Canada, everything I said is true. You could live in Canada, but be actually a citizen of France or the UK. But if you live in Canada, you're a Canadian taxpayer. So that's everything I've said is about residents of Canada.
Great. What is the time frame for setting up a CBT?
Well, the time frame is always within your time frame. So if you call us up and you say the closing is in 30 days, or the closing is in 45 days, or the closing is in 60 days, or even if the closing is in 15 days, I promise you we get it done.
And we've got another question regarding CBT. Can you share the approximate cost of setting up a CBT?
Yeah, the rates somewhere between 5,000 and 7,500. The big benefit for the Canadians is we charge in Canadian dollars, which is like a 35% discount.
Okay, and can it be set up now for a client that wishes to sell their Florida home now?
No, I'd say that's a waste of money. If you're planning to sell, there's no need to set it up, because it's good for Canadians who are buying for mid to long term hold, or Canadians who already own. But if you're already planning to sell now, like within the next 6 months, why do a trust? You don't need it. Unless you are, critically ill and you may not make it.
Okay, great. Well, David, I don't see any other questions here, and this was another fantastic presentation. If anyone else has any other questions, but well, actually, you know what, David, there's some more rolling in if you have time.
Well, yes, I allocated an hour, so I certainly have time.
Okay, so I spoke too soon here. So the next question is, my brothers own 2 houses here in their names, and they are selling one with a gain and purchasing a new one using the proceeds. What is the best financial strategy?
Well, not doing a 1031 for sure. Okay. We can represent the client on the sale and handle the FERPTA issues. And on the purchase, that we would probably create a trust instead of them owning it personally, and organize that for the closing.
And how about for the tax savings?
So the important thing is to look at what is the gross sales price and what can be deducted to reduce the capital gain. So we check out a lot of different things: realtors' commissions, special assessments, capital improvements, and start cost when they purchase. And we grind down the gross gain to a net gain. And we deal with the accountants on both sides of the border to explain everything. And we deal with the FERPTA. So it has to be done the right way to get the best, the minimal, to minimize the amount of tax.